record. You can record. Thank you. Let me welcome all the participants of this roundtable conversation. Our conversation is a part of the online Budapest seminar of the Conference of European Succession Law and the Matrimonial Property Law, Interconnections. And it can be online accessed due to the participation rules. I'm Viktor Máté, notary, and the honor is mine to be the moderator of this roundtable conversation. First of all, I would like to say thank you for accepting our invitation in person to Hana Hoblaj from Croatia and Martin Margonski from Poland. Both are deputy notaries. To Põtter, notary from Estonia, to Marco Rizzuti, who is the researcher of the private law University of Florence from Italy, and Rembert from Germany, from the German Notarial Institute, who is the director of the Department of for Private International Law there. So thank you, and thank to all of you again. As we have a quite interesting topic, and you are experienced professionals, I'm sure that this conversation will be very fruitful and useful for those who try to find answers to matrimonial questions in international relations. The title of the roundtable conversation is Asset Planning Without Borders, which is in close connection with the subject of the previous presentations. Our first question is the foreign legal forms of cohabitation. So would you please present your own system, please? I give the floor to Croatia. Thank you.
Yes, thank you. The Croatian legal system recognizes formal and informal forms of cohabitation. Formal cohabitations are marriage and life partnership. Marriage is considered to be the union of the life of a man and a woman, and life partnership is a community of family life of two persons of the same sex concluded before a competent body. Informal cohabitations are extramarital union and informal life partnership. Extramarital union is considered to be a life union of unmarried woman and unmarried man, lasting at least 3 years or less if a joint child was born in that union. And the informal life partnership is considered to be a community of family life of two persons of the same sex who have not entered into a life partnership, and the community lasts longer than 3 years. Croatian laws recognize and attach equal inheritance, taxation, and property effect to all aforesaid cohabitations. Thank you.
Thank you very much. Then I give the floor to Poland.
Yes, thank you very much. Well, giving you the Polish point of view, I have to distinguish between different sex marriages and homosexual couples. In case of different sex marriages, Poland does not apply the EU matrimonial property regulation. And under Polish law, the law applicable to matrimonial property matters has to be identified and also applied, also in case of foreign law, ex officio. And that applies both to notaries and to courts. So, as a rule of thumb, the Poles accept foreign marriages in terms of their property consequences as they are. And it's something you cannot say in case of homosexual couples. Neither homosexual marriages nor registered partnerships are known to Polish legal system. And as a notary working on a daily basis in Polish-German cases, I always recommend the parties living in such marriages or partnerships registered in Germany not to rely on their legal status resulting from German law in Poland. because in the current political situation, the trend to apply the ordre public clause is very clear. So the party is good advised to make a will or to give the other partner a far-reaching power of attorney, including, for instance, the right to medical information.
Mm.
Thank you.
Thank you very much. And what is the situation in Estonia?
Hello. In Estonia, we have a formal relationship, obviously, a marriage, which is only allowed for the different sex marriages, yes. But we have also registered partnership. The law was adopted, but what happened was that no one adopted taking measures, which means that in fact we do have the law registered partnership. It's not possible to register partnership itself. However, according to this law, the partners of same sex and different sex are allowed to conclude partnership agreements whereby it is considered more like organizing their family life. So there are only two forms. We don't have any principles applying that there are just cohabitation of the couple. There are no legislations about that. It has to be in some form of either the marriage or then the partnership agreement must be concluded to have it more like legal effect.
Mm-hmm. Okay, the connection was a little bit unstable, but I heard. Thank you very much. Italy, please.
Yes, many thanks for the invitation in this conference, first of all. And now coming to our issue for legal forms of cohabitation. In Italy, we have different kinds of family models that are recognized by the law in different degrees with different effects. At least 4 different forms of cohabitation. Marriage, that is the more traditional one, of course, and marriage can be stipulated only by different sex couples, as in the other countries mentioned before. Marriage can be religious according to the concordat, or can be civil marriage, but for our purpose is the same for civil law effects. Then we have the civil union introduced in 2016. Civil union is only for same-sex couples. The effects are quite similar to the marriage effects, but not exactly the same. There is a difference. So we have this kind of separated but equal system to 2 different institutions. One for marriage for different sex couples, and the other one, civil union, only for same-sex couple. A same-sex couple cannot be married, and a different sex couple cannot enter into a civil union. Mm-hmm. The tracks are separated. Then we have cohabitation outside from marriage or from civil union, but also cohabitation has some legal effects according to the same Act of 2016. That in this case is it's not just something totally new, but it is new with regard to civil union, but with regard to cohabitation, it is just a sort of restatement of previous norms and the previous case law. Cohabitation can be registered with a contract of cohabitation or simply registered at the city hall in a specific register of cohabitations. But we can also have a simple de facto cohabitation. And also with the married de facto cohabitation, some very limited legal effects are possible because case law in the past decades had recognized some effects also to married de facto situations. And it is relevant because not each and every cohabitation can be registered. Example given, a cohabitation between a person who is married with another person and is separated but not yet divorced, and now he is cohabiting with a third party. This kind of cohabitation cannot be registered. So this cohabitation is merely de facto. But some limited effects are possible. I think about the damages in case of death, or the so-called natural obligations are possible also in this case, because the quite old case law has recognized this kind of extract with regard to all kinds of cohabitation. And when I speak about cohabitation, there are no differences between different sex couples and same-sex couples. The difference is relevant with regard to marriage and civil union, but when I speak about cohabitation, both registered or unregistered, it is all the same. And when it comes to foreign legal forms of cohabitation to be recognized in Italy, that we cannot recognize all the foreign forms of cohabitation as such. The most relevant example is for same-sex marriage. If a same-sex marriage is contracted abroad, in France, Netherlands, Spain, Germany, in a country where same-sex marriage is possible, in Italy it will be recognized only as a civil union. It will have to be legally converted into the other legal institution. So the effect will be not full, not all the possible effects of the marriage as such, but the slightly different effects of civil union. Many thanks for your kind attention.
Thank you very much. Germany, please.
Okay, in Germany, the situation is very simple. We, as formal form of cohabitation, we only have the marriage. The marriage is the only formalized form of cohabitation actually available in Germany. Since September 2017, two persons can marry each other without having regard to their sex. So we have the heterosexual marriage and we also have the homosexual marriage. Before in 2001, like in Italy and in other countries, the registered life partnership has been introduced. That was only for homosexual couples, and it had nearly the same effects in family law and succession law and other civil law sections like the marriage. But that registered life marriage, it was abolished with the opening of the marriage to homosexual couples, and therefore we only have some resting registered life marriages which have not been transformed to a marriage. At least we, of course, in fact, have a lot of de facto cohabitations between two people of same sex or different sex or more people together. But these relationships, they have no legal effects in family law or in inheritance law. Okay.
Thank you. That was very interesting to hear all these situations. I think the Hungarian situation is quite similar to the German one, as we have registered marriage between different sex parties and registered life partnership between the same-sex parties, both having the same matrimonial property effects and the inheritance relations as well. Also, we have de facto cohabitation in which the relations have to be regulated with contracts and wills. The next question to which we can jump is the question that do you have any registers in the field of matrimonial property agreements in your country? So Croatia, please.
Well, in Croatia, there is no register about regarding matrimonial property or matrimonial agreement. We only have land to register about the property, and that's all.
Okay, thank you very much. Poland?
There is no register on matrimonial agreements or choice of law agreements, neither Polish nor foreign. The only place one can, in certain cases, make a matrimonial agreement public is the business register. In cases of individual entrepreneurs or partnerships. Since the statutory regime in Poland is the community of property, the question of the liability of the other spouse with the common property, but also the question of the consent of the other spouse is in some cases of great political, practical importance. And therefore, it is recommendable to review an agreement leading to separation of assets in one of the applicable business registers.
Thank you very much. Estonia, please.
In Estonia, we do have matrimonial property registry, and it is considered that the data in the registry has legal effect also towards third parties. In this registry, it is possible for the spouses, when they conclude matrimonial property agreement, to register their agreement. They have the possibility to show or to choose between 3 different matrimonial property regimes available in Estonia. And those regimes which they have chosen, or if there are any differences into it, and then they can register it in the registry, and it is the public information. And also in the same registry, it is possible for the spouses to register the choice of law agreement. Usually they are done in the matrimonial property agreements, where they can show what is the applicable law. And when we are speaking of foreign matrimonial property agreements, then mostly if they are regulating the matters between the spouses by the foreign law, the agreement itself cannot be registered. However, if it has a choice of law in it, then the choice of law can be registered also from deriving from foreign agreements in the Estonian matrimonial property registry. So, and usually, or what happens in the practice is we have, of course, also land registry, which has also legal effects. And sometimes I think that we have 2 registries having legal effects. We have land registry, where we can see only the name of one spouse. But in fact, when you go into the matter, you can find out that it is the joint property of the spouses. It was just that in the past, the practice was just to show only one name in the registry. And then we have matrimonial property registry, where you presume it to be the community property because there is no registration in there. So there is kind of, sometimes there may be a conflict between the 2 registries or the data that is available in it, but they both have legal effect. Thank you.
Thank you very much. That was very interesting to hear. Italy, please.
Thanks again. Well, in Italy, we have a system of public registration for matrimonial property agreements, that because when with these agreements, a married couple chooses a regime that is different from the default regime, this agreement is registered in the same register of the city hall where marriages are registered. Moreover, we have also another register after the reform of 2016 where the contracts of cohabitations can be registered. It is not so often used, but we have also this other register with, as I said, the contract of cohabitation. The effects are different, but maybe we will speak about them in another question. Moreover, we have the general ordinary land register property, that is another kind of public registration system. And in this case, I have to specify that in Italy we have different systems of public registration of land in the different part of the country, because in the most part of the regions we have a system that is quite similar to the French one, a system where the registration has the so-called declarative effect, because property is transferred and acquired because of the mere consent, the mere contractual agreement, at least at the level of law in books, because if we look to law in action, it's quite different, but at least from a general point of view, this is the French-like system. But in some regions in the northern eastern part of Italy, the region that were annexed to Italy only after the First World War, the Austrian system is still in force. So in this case, the registration is constitutive. It has a constitutive effect on the property transfer, something quite similar to the Austrian, German, and other systems of Central Europe. In case, with regard to all these different systems, when we have to deal with foreign registers, we have to consider that At the moment, we have not at the European level a private international law of public registration in a regulation of harmonization. We have the private international law harmonized in successions, in families, but not in public registration. But in any case, we have learned after the judgment of the European Court in the Kubitska case that the law applicable to the acquisition of the ways of acquisition of rights, succession law, or in our maybe family property law, and so on, will have to be applied, notwithstanding the possible different internal provisions regarding public registration systems. So the whole framework is quite complicated, but we have to manage it.
Mm-hmm. Very much. And what is the situation in Germany?
Okay, in Germany, we have a statutory regime of community of gains. This means that the people also, if they are married, generally can dispose freely of their property. And now if they enter into a marital property agreement and they agree on for example, community of gains, one spouse should maybe limited in his power to dispose of the property. And therefore, they have a rule in German law that this restriction to dispose of his property will not have effect of a third party who is acting bona fide, in good faith, unless it has been, the agreement has been registered with the matrimonial property register, the Güterrechtsregister. Therefore, such a restriction is not necessary for the effectivity of the matrimonial agreement, but for the effect against third parties. It will destroy the good faith of any third party dealing with a married person. The register is allocated with the local codes, and it is very rarely used. I never heard of any case that a married property agreement has been registered with a matrimonial property register. And I also never heard that anyone ever had a look into this register. And what is interesting for private international law cases is that also the fact that a couple is living in a community system according to foreign law, that may also be registered in that matrimonial property register. And the effect is the same. In that case, any third party may not rely on good faith that a married person is able to dispose of his property freely if there's any restriction under that foreign matrimonial property law. Okay.
Thank you very much. In Hungary, we also have a register of contract between the spouses and also partners in life. Moreover, the property agreements between de facto cohabitators can also be registered here. The registration is not a requirement of validity here also. The next question is how your country defines property law systems applicable if there is no property agreement between the spouses or the partners. So I mean, how can you determine the applicable law? Furthermore, does your country have a bilateral agreement with someone in such a subject? That's I would like to give you a small explanation previously. So if there would be property agreement, then in this agreement, the parties would have the possibility to determine the applicable law. But supposing that there is no agreement, what shall determine the applicable law? As it is a quite composite question, I give you the example of Hungary first. So Hungary is not participating in the EU regulation of 2016/1103 of the matrimonial property regime. Therefore, the applicable law of matrimonial property can be determined upon the prescriptions of the Act on Private International Law of Hungary. So basically, a citizenship of spouses shall determine it. If it is different, so I mean the citizenship of the parties are different, then the law of the state of their last common usual residence shall be applicable. In the lack of this, the law of the acting court is to be applied. The spouses or possible future spouses, same and different sex but registered spouses, can choose the applicable law with limitation, as I see. The limitation is that they can only choose the law due to one of their citizenship or the place of usual residence at the time of conclusion of the property agreement. Or they can also choose the law of the acting court, but this is only a later case. So this is basically in accordance with the choice of law in the EU regulation, as I see. Certainly, if we have a bilateral agreement with any country, the rules of this agreement are to be applied. So I'm very interested, what is the situation in your countries in accordance with that? So Croatia, please. What is the situation in your country?
Yeah, well, in Croatia, a law system recognizes matrimonial property regime and separate property regime. And spouses may regulate their relations by property agreement. And if they do not have an agreement, then the rules of law will apply. And by the law, matrimonial property is considered to be the property acquired by the spouses through work during the marriage or originating from that property. And it is co-owned by spouses in equal parts. The spouse's own property is considered property acquired before marriage or during the marriage, acquired by inheritance or gift. And the rules of Croatian private international law referring to matrimonial property regime indicated the application of the regulation of matrimonial property regime. So we have an old bilateral international agreement taken over by Croatia by succession. It's agreement of the regulation of legal relations in civil, family and criminal matters between Yugoslavia and the Czech Slovak Republic from 1964, but this is not anymore.
Thank you very much.
Thank you.
Poland, you are muted. You are muted. Thank you.
Under Polish private international law, the law applicable, if not chosen, depends on the current common nationality of the spouses. Current common nationality, so it's changeable. And if the spouses do not share a common nationality, the law of the state of their, again, current residence or habitual residence applies. And that's the national regulation under private international law. Poland does have a bilateral agreements with actually most neighbors. Leaving aside Germany, we have them with the Czech Republic, Slovakia, Ukraine, Belarus, all three Baltic states, Russia, France, Austria, Hungary, Bulgaria, Romania, successor states of former Yugoslavia, but also Vietnam, Mongolia, Cuba, and North Korea. And some of those states apply the EU regulation. That's Bulgaria, France, Croatia, Austria, Slovenia, and the Czech Republic. And for since Poland does not apply, is a third state for the matrimonial property regulation. That's an interesting case because in those cases, those bilateral agreements take precedence over the EU regulation in those bilateral cases.
Thank you very much. It was very good to hear that the family law relations are in good condition between Poland and North Korea. So that's very interesting. Okay, Estonia, please. Do you have bilateral agreement with North Korea as well?
No, we don't have a bilateral agreement with North Korea. We have bilateral agreements with Russia, Ukraine, Poland, Latvia, and Lithuania only. Luckily, I think, because in my view, the private international law rules in the bilateral legal aid agreements are very, very poor and give no legal certainty for the couples. When we are speaking of the Estonian private international law rules, then we are not parties to the EU regulation. However, we have quite similar rules. According to our laws, the applicable law would be the law of the place of residence of the spouses at the time when they concluded the marriage, which means that it should be always the same result. If they don't have the common place of residence, then the common nationality, and failing the common nationality, then it will be the state where they last had common residence, with the condition that one still remains there. And if that fails also, then it will be the state with whom they are mostly connected. And in my practice, I rarely go more far than point one, the common place of residence at the time of when the marriage is celebrated. So, but in practice, we do have legal aid agreements with Russia, Ukraine. They provide that the applicable law would be the place of residence of the spouses. If they don't have that, then the common nationality. Failing that, it would be where they were last living, or then which country they are mostly connected. And why I think it's a bad regulation is that if the couple lives today in Estonia, then it is the Estonian law. If they tomorrow move to Russia, then it will be a Russian law. And that would mean that for different items of property that they acquire, they would have completely different legal consequences. Even if in Estonia, the default rule would be the community property law, then even if in other countries it is also the community property law, it might have completely different legal meanings, because community property is not community property by the same definition in each country. And then in the legal aid agreement with Latvia, Lithuania, the principle is the same, that the first rule will be the common place of residence at the time when we are dealing with a matter, for example, buying a flat, whatever, the notaries have to establish it. But in those agreements, there is a provision saying that the matrimonial property law provisions don't apply to immovable property, which means that according to the legal aid agreements for immovable property, it is the law where the property is situated, which means that they might be Estonian and Latvian national, they have property in Germany, German law applies for property in Estonia, Estonian law applies, and then which means for us in Estonia, it's a community property. For Germany, it is the separate property, but it's the same couple. So it's kind of, I think there is no legal certainty at all. And then we have the agreement with Poland. In this agreement, it is the same nationality of the couple. And if they are in different nationalities, which is usually the case for us looking into the private law, international law matters, then we would look at the place of residence at the time when we are dealing with the matter, which means again that today they live in one country, tomorrow in another country. So there is absolutely no legal certainty. And I think it's questionable if we are looking at the legal aid agreements, then whether by those agreements the couples are even allowed to choose the applicable law, because the legal aid agreements don't have even that possibility. So according to Estonian national law, we can choose, they can choose either the law of nationality or the law of place of residence of one of the spouses. But if they are nationals of the countries with whom we have the legal aid agreements, then I must say, stop, I'm not sure you can do that. Because if you move, then you really should go and consider, according to the laws of the country where you will residing in the future, you should go and see again, maybe you need a new matrimonial property agreement to make sure that your wishes go as you want. And in my practice, I think that notaries have a very, very important role in this, because I think personally that even if people are buying immovable property, which must be in authentic form in Estonia, or shares of companies, for example, whenever I can see that they have different nationalities, different places of residences, or they have been living in a different country at the time when they concluded the marriage, I think it's my place to tell them that, hey, you have to think about it. And usually people say that, oh, we don't need any matrimonial property agreements because with us, divorces don't happen. But then you have to remind them that death is something that we are never saved of. And this is the place where in succession cases where I can really see that it is such an important question. But if you die, I have no one even to ask, where did you reside or what law at the time when you bought a specific item. So I think the legal aid agreements are really bad in private international law matters. They give no legal certainty for the couples. They don't serve the purpose they should serve. So yeah, this is our situation. Thank you.
Thank you very much. It was very, very complex. And what are the answers to these questions in Italy?
Well, first of all, in Italy, the default regime for matrimonial property is the regime of community property. So if there is no agreement between the parties, the applicable regime will be just community of acquisitions. But in many cases, the married couples stipulate matrimonial property agreements that are called matrimonial conventions in our civil code, and stipulating these kind of agreements, they can obtain the application of a different regime, that is separation of property. And these agreements have to be registered at the city hall, as I said in the previous answer. On the other hand, with regard to the partners of a cohabitation, the situation is different. It is quite opposite, because with regard to the partners of a cohabitation, the default regime is separation of property. And if the parties want to obtain a community property regime, they have to stipulate a contract of cohabitation that has to be registered in the other register mentioned before. So exactly the opposite situation. Two other specifications. With regard to civil union, the regime is the same of marriage. As I said before, marriage is for different sex couples, civil union for same-sex couples, but the system is very similar. Also in this case, for civil union, we have community property or possible agreements that change the regime. Another specification that I think would be interesting is that with regard to married couples, different sex couples, and also with regard, as far as I know, to same-sex couples in civil unions, it is quite common to stipulate matrimonial property agreements to change the regime. The default regime is community property, but a lot of people prefer separation of property, and so they stipulate this kind of agreements. On the other side, with regard to the cohabitations, as far as I know, the most part of the people are happy with the separation of property, and it is very rare to stipulate a cohabitation contract just to pass to the community property system. So we can say, we can see that in both cases, people try to get separation of property because it is considered easier to manage, while community property is more complicated. So the spouses have community property as default regime, and quite often they choose the different regime. The cohabitant couples, on the other hand, have as a legal regime the separation of property, and in most part of the cases they maintain this. Maybe if they want to pass to community property, they just get married. It is more usual than to remain cohabitants and to sign a cohabitation contract just in order to have community property regime. With regard to the international private law profiles, I think that I will answer directly in the next question, because the answer will be exactly the same, because in Italy we have the enhanced cooperation and the regulations apply. So thanks.
Thank you very much. And Germany, please.
Okay, in Germany we distinguish between marriages concluded on or after January 29, 2019, and marriages concluded before that days. Every marriage which has been concluded on or after January 29, 2019 is subject to the European regulation on matrimonial property regime. And this applies regardless to homosexual marriages and to heterosexual marriage. They all are subject to that European regulation. As far as the marriages concluded before January 29, 2019 are concerned, we also distinguish between heterosexual marriages and homosexual marriages. The heterosexual marriages are first subject to the matrimonial property law, which has been chosen by the parties by marriage agreement, and they were able to choose either the national law of one of the parties at the time of the agreement, or the law which enforce at the habitual residence of one or both of the parties at the time of the agreement, or with regard to immovable property, the lex Rizzuti, the law of the place where this immovable property is located. For example, they can choose German law for immovable property situated in Munich, and French law for immovable property situated in Cannes at the Côte d'Azur, or like that. Okay, in case they have not made any choice of law agreement, we have the objective determination of the applicable law, and that first of all is the common national law of the parties at the time of marriage. This is an immutable determination. That means that if the couple changes its nationality later, the common national law at the time of marriage will remain applicable. That will not change. A change might be possible by way of remission, renvoi. You know that case. Okay, in the case the husband and wife at the time of marriage had no common nationality, the law of the place in which they both had their habitual residence at the time of marriage will apply. This is we have to take account, other than in the European regulation, the first habitual residence will not be regarded. That we only will take regard at the time of marriage. If they already had the habitual marriage in the same state at that time, that law will apply. And if they will have the habitual residence after marriage, then we have to take this third step. That means we will apply the law of the state with which the parties have their most closest relationship at the time of marriage. And that in most cases might be the intended first habitual residence of the parties. Okay, that's a case of the heterosexual marriage. With regard to homosexual marriage, just these have been regarded like a registered partnership, and we applied the law of the place of registration of the marriage to those couples. That seems a little bit discriminative too, because we have a difference between homosexual and heterosexual marriages. But if we apply the place of the registration of the marriage, that will ensure that we apply a law which recognizes this homosexual marriages. For example, if we have two Polish people who married in Germany, then we, according to that old law, we will not apply Polish family law, which does not recognize the homosexual marriage, but we will apply German law, which grants a matrimonial property regime for those people. Okay, and now we regard to the international conventions. Germany is part to two conventions on the field of matrimonial property law. The first one is the convention with the Empire of Persia, dating from February 17, 19, and 29. And according to Section 8, Paragraph 3 of that convention, the common national law will apply. That is to say, if now two Iranian people marry in Germany and have their common place of habitual residence in Germany, we will not apply a German law according to the European regulation, but we will apply the Iranian family law according to that bilateral agreement with the Empire of Persia. A second international convention, that is the International Convention with France on the creation of a uniform contractual property regime of community of gains, also called Wahlzugewinngemeinschaft. This convention does not include any law of conflict rules, but it creates some uniform property regime, like the German statutory regime of Zugewinngemeinschaft, or the French regime of Communauté like the community of gains existing under French law. Okay.
Okay, thank you very much. I'm sure, and I think that these answers all gave us very important and widespread international information. Furthermore, most of you gave answers to our next questions, partly. We can jump to. And this question shall be our last question before the conclusion, that how does the existence of a property agreement affect the law applicable to property relations in the countries that apply the regulations, and also in those that not apply the regulations. So what is the opinion and the situation in Croatia?
In Croatia, we apply the regulation of matrimonial property regime and also the regulation of the property consequences of registered partnership. So the regulation of matrimonial property regime should enable spouses to know in advance which law will apply to their matrimonial property regime, and that law should apply even if it is not the law of the member state. In Croatia, spouses must be able to organize their matrimonial property regime in advance by matrimonial agreement. According to Croatian family law, spouses may not choose the applicable origin law if both spouses are Croatian citizens. In Croatia, the regulation of matrimonial property regime should apply in the context of matrimonial property regime having cross-border implication. That is to say, if the spouses have property or habitual residence or citizenship in different states. The regulation should be binding in its entirety and directly applicable in the Republic of Croatia, which participates in enhanced cooperation in the area of jurisdiction, applicable law, and the recognition and enforcement of decision of the property regime of international couples. The regulation of matrimonial property regime authorizes spouses to choose the law applicable to their matrimonial property regime among the laws with which they have close links because of habitual residence or their nationality. And this choice may be made at any moment before marriage, at the time of the conclusion of the marriage, or during the marriage by the matrimonial property agreement. For reasons of legal certainty, applicable law should govern the matrimonial property as a whole, that is to say, regardless of whether the assets are located in another member state or in a third state. The rules of the formal validity of a matrimonial property agreement requires that the agreement should be at least expressed in writing, dated, and signed by both spouses. And by Croatian family law, the signatures of both spouses should be certified by notary, which is additional rule, formal rule, and that rule should be complied with. The form of authentic instrument, that is agreement written by the notary, is optional in general, but it is obligatory for persons deprived of legal capacity. As an exception from the contractual form, spouses are allowed to apply together to land registry to register their shares on real estate, which was registered previously as a sole ownership. Thank you.
Thank you very much. Then let us see the situation in a country which is not participating in these EU regulations. Poland, please.
The Polish private international law allows, as mentioned, the choice of law applicable to matrimonial property, similarly to the EU regulation. But under Polish law, the choice can be made expressly, but it can also be of implicit nature. So it can be demonstrated by the terms of the agreement. And that's the answer to your question, because in many cases, an agreement made under foreign law would also be a source of implicit choice of law.
Thank you very much. Now we see another non-participating country, Estonia.
In Estonia, as I said also before, it is possible for the spouses to choose the applicable law and also to register it in the matrimonial property registry that they have made the choice. And when they would conclude matrimonial property agreements in Estonia, then it must be authenticated by a notary. The spouses must conclude it personally, which means they cannot use powers of attorneys. They have to be presented themselves. And for the agreement to have effect towards third parties, it must be registered. In practice, most of the agreements are registered, and it's done directly by a notary when they are concluded the agreements, because the notaries are actually making the entries into the matrimonial property registry, which is kept by the Estonian Chamber of Notaries. Now, we are not parties to the EU regulation, but I think that those countries who are not parties to the EU regulation are even in a worse situation than the countries who are, because yes, we don't have to apply it, but we do have to apply it in cases of renvoi. If our national laws refer to the law of a country who takes part of the regulation, then we have to look at the private international law rules derived from the regulation. But we still have to apply it. I think we cannot say that we are not absolutely looking at them. So worse situation, I think, again, because we have to know our private international law, the national laws of other countries, plus the regulation. Thank you.
Thank you very much. Maybe you shall be the most experienced international family lawyers. Okay, Italy, please.
Yes, thanks. Italy is a country that participates to the European enhanced cooperation in the matter of matrimonial property regimes, Regulation 1103, and also the enhanced cooperation in the matter of patrimonial effects of registered partnerships, Regulation 1104. Both regulations are of the year 2016 and are entered to force on January 2019, as all you know. Well, both regulations have an article, the article 20 in both regulations, the number is the same, Article 20, that states that regulations have universal application. So for country that participates to the cooperation and are under the regulations, we have always to apply the criteria set by the regulation themselves in order to determine the applicable law. Therefore, choices of law or other possibility will have the place only if and when regulations provide for the choices of law or for other criteria. There is no place left at the moment for other criteria for national private law or for bilateral agreements and so on. Of course, they can be still relevant for the past situations because regulations are entered into force only quite recently. But if we look at the situation of a couple that marries today, the only point of reference are the regulations, and so from this point of view, the situation is slightly simplified because we have just one common framework, and we have to apply the criteria of the regulation not in all cases, both when we deal with transnational situations. Example given, Italy and France, both countries under regulation, but also Italy and North Korea. The criteria to be applied are, in any case, the criteria of the regulation, because the regulation has, as I said, universal application that is quite common in the field of this kind of private international law, European harmonization regulations, or also in the succession regulation, we can find the same laws of universal application and so on. In this way, I can answer to your question and also to the second part of your previous question, because in any case, we have to go to the regulations and not to other kind of possible agreements, at least for the today's situations. And for the past situation, it is different, of course, because in the past, the regulations were not applicable.
Thank you very much. And finally, let's see the opinion of Germany.
Okay, in Germany, I think the unification of private international law in the field of matrimonial property law by the EU regulation release the international estate planning on matrimonial property. Although I think that, yes, the most important means for estate planning in international field is the choice of law clause, and in the meanwhile most countries in Europe are already recognize the choice of law clause in matrimonial property, like Poland, and so I think unification in that field is not of such absolute value. And I think also that also on the European matrimonial property regulation, an implicit choice of law might be valid. We only have that formal requirements, that is that and a choice of law clause has to be made in the form of a matrimonial property agreement. And there we have one thing which in practice might be a backstep. That is we cannot apply the lex loci contractus, or the law of the place of the agreement with regard to the formal validity of the agreement. For example, if we have a couple of two Germans residing in Germany who are going to Italy for marriage, and there they declare that they want to live in the regime of a separate property, this declaration is valid according to Italian law, but it might not be recognized under the European regulation, because this form, the declaration against the civil servant, is not valid according to German law, the law of the place of common habitual residence of the spouses. And also, if we have a couple, German Swiss couple, and they agree on community property in Switzerland, also in that case, the German courts will have to apply the place of the German habitual residence of one of the spouses, and it will be questionable whether the notarization of the agreement by the Swiss notary is of equal validity to the notarization by a German notary public. And yes, we will see by the jurisprudence of the European Court how this requirement of the European regulation with regard to the formal validity of the marital property agreement, and also on the validity of a choice of law clause regarding the matrimonial property religion will be recognized. Okay.
Thank you very much. And now we arrived finally to the conclusion. So I'm waiting for the conclusions that, in the line of the above, in your opinion, can the matrimonial property situation be better planned in countries that are party to the agreement than in those that are not, or can be difference at all, or do you have any other opinion in this question? So Croatia, please.
For reasons of legal certainty and in order to avoid fragmentation of the matrimonial property regime, the law applicable to matrimonial property regime should govern the regime as a whole. That is to say, the property covered by that regime, irrespective of the nature of assets and regardless of whether the assets are located in another member state or in a third state. Therefore, in my opinion, the matrimonial property regime can be better planned in the states participating in the regulation.
Thank you very much. Poland, please.
Yes, if you're asking me how problematic the lack of Polish participation in the EU regulation is, in my view, well, the planning of the matrimonial property situation during the marriage is, from my point of view, not the key problem. since the choice of law rules are similar in the regulation and in the in Polish private international law. Of course, the connecting factors are different, so it could be better. But the real problems resulting from the lack of Polish participation in the EU regulation start when the marriage is over, and they concern they result from the lack or they concern the jurisdiction. They concern the recognition of decisions and the coordination of jurisdiction, coordination between member states applying the EU matrimonial property regulation, but also coordination with jurisdiction in succession matters. Poland does not recognize foreign decisions in matrimonial property matters in relation to Polish immovable property, where the exclusive jurisdiction of Polish courts applies. And from my point of view, that's the systematic problem. And another problem mentioned by Eve is the question of choice of law in cases when bilateral agreements apply. Most of those bilateral agreements do not mention choice of law, since they were prepared in times when choice of law was not an issue. And the conservative position taken in such cases by Polish notary treats those bilateral agreements as a closed system of regulation, which has priority as a whole, and thus usually excludes choice of law. So our answer is different to what Eve has been telling us, because notaries in Estonia are not sure. We don't make choice of law. We don't accept it because we tend to believe, or we fear, that it's not permitted when bilateral agreements apply. And that makes planning matrimonial property very difficult, especially in those cases when the bilateral agreement leads to different law applicable to movables and immovables, because you have one marriage with two different law applicable. And we have that problem in relation to Ukraine. And if you realize that we've have experienced about 2 million Ukrainian citizens who moved to Poland, it is a real problem from my point of view, a systematic problem. Thank you.
Thank you very much. So, Eve, Estonia, would you please
I completely agree with what Hana has said, that irrespective of the location of the property, for legal certainty reasons, the applicable law should be always the same, irrespective where they live today or tomorrow, it should be still the same, or if they change their nationality. So this is the reason why I personally think that the provisions and the regulation are good ones, because there is only one connecting factor, and if everybody is applying it the same rule, then it provides also more legal certainty for the spouses. Questionable is whether it should have retroactive effect or not. Maybe this is a different topic to discuss, but I think that especially if I speak of Estonia, then the cases where we have to apply the legal aid agreements, the bilateral agreements, those are the poor cases where we cannot preserve that legal certainty that maybe there should be. And in my practice, I can say that this is not a question that I apply only when the marriage ends. I apply it when they buy or sell immovable property. This is always when you have to establish, is it the joint property by Estonian law, or is it a different law or different country rules that I have to look at? So I think that, as I said before, I think notaries have a very big role in here to pay attention to those factors they should do, I think, to explain people, because for people, for couples, they realize that it's the problem only when something happens, when they divorce or someone dies. So, but then it's too late for them to regulate anything or to conclude at least the agreement where they say that there is applicable law. And when we are speaking of the legal aid agreements, as I said before, as Martin also pointed out, yes, legal aid agreements do not allow the couples to choose the applicable law. On the other hand, they oblige you to treat people the same way. There should be no discrimination. So there is again conflict between the two different rules, which again I think shows that they are not the best provisions of private international law and give absolutely no legal certainty. So yes, it should be better planned.
Thank you very much. Thank you. Italy, please.
Thanks. Well, in my opinion, at the moment, it is quite early for an evaluation of the implementation of both the regulations in Italy. As I said, they entered into force only in January 2019, something more than a year ago. At the moment, we have no case law at the level of the European Court of Justice, nor, as far as I know, at the domestic level of Italy. So it is quite early to evaluate in concluding terms how the implementation of those regulations is going on. I think it will produce good results, but it's quite early to say. At the moment, maybe we can just focus on some possible hypothetical problems of the application of the regulations. I refer, of course, only to the Italian legal context, and maybe I can find some possible problems with regard to an issue that we have already discussed in this round table. If we go back to the first question, the different models of family, the different models of cohabitation, we have noticed that in all our country, one of the most relevant issues is the different degree of recognition for different sex couples and same-sex couples. It is something that almost all of us have talked about in different forms, maybe for different kind of regulations or in the past, in the present. Okay, but this is an issue. Well, it may be an issue also under the regulations with regard to the Italian context, because of the specific Italian rule that I mentioned in my first answer, when I said that in Italy we have marriage only for different sex couples and civil union only for same-sex couples, and a foreign same-sex marriage has to be converted into an internal civil union in order to produce effect in Italy. Okay, this is the domestic provision. But when it comes to apply the regulations, when we have to decide which criteria for conflict of laws or which criteria for jurisdiction and so on, in this case, a same-sex marriage that has been contracted abroad as marriage, so it is under regulation 1103. Then it is converted by the Italian legal system into a civil union that maybe is under the other regulation. Then which of the two regulations will be applicable, and then which set of criteria will be applicable, and then again which final and specific applicable law we will have to find. Of course, we can solve the problem if we could say that civil union is so similar to marriage that maybe civil union can be considered also under regulation 1103. But it is a quite complex interpretive option. Maybe we have two regulations just because of this, just because there is a difference between marriage and civil union. And if the difference remains, then in this kind of particular situation, legal conversion of a foreign institution into another domestic institution, then we have an unsolved problem, an outstanding issue of which kind of criteria apply. In many cases, the criteria are similar, so then there is, maybe we cannot have concrete problems, but in some cases, the criteria are different. And so I think that after or before, the problem will emerge and will be submitted to the attention of our courts and also to and maybe also to the European courts. And then we will have to discuss about the possible solutions. Many thanks again.
Thank you very much. Thanks. And Germany, please.
Okay, I find that very interesting, and in Italy, because in Germany too, before the entering into force of the European conventions, same-sex marriages under Germany private international law have been treated as like a registered partnership only for the issue of private international law. And there was a big discussion in Germany whether under the EU regulation same-sex marriages should be treated as a registered partnership in the meaning of the partnership regulation, or as marriages in the meaning of the matrimonial property regulation. And that question has been decided by the German legislator by introducing a new section into the German introductory law to the civil code, and according to Article 17b, paragraph 5, registered partnerships, same-sex marriages shall be treated like a registered partnership under German private international law, but they should be treated like a marriage under the European matrimonial property regulation. So we have, I think with the majority of the other European states who are a member also of the matrimonial property regulation, same-sex marriages will be treated as marriages and not as registered partnerships in the meaning of the partnership regulation. Oh. Okay, and further, I have to add that according to our opinion, for the legal certainty of the spouses in case of matrimonial property, it's very important that the matrimonial property regime will not change if the spouses are moving from one state to another state of the union, and therefore I think it's a very good regulation that also in the matrimonial property regulation, the matrimonial property regime is connected to the first habitual residence of the spouses and will not change if the spouses move later, and we only have a very narrow and exception for cases where they live a very long time in another state and both spouses rely on the matrimonial property regime is subject to the law of that other state. Then the court is able to apply that other law, a very narrow exception, and we will see in which cases that will be applied and practiced. Okay.
Thank you very much. That was very interesting, and I quite understand all the opinions of you. In my part and in my point of view, I also have a conclusion of this topic. Remaining on the surface, I think that as the Hungarian system is in respect of the choice of applicable law, gives the same possibilities as the EU regulation, as I said previously. So I think that the difference is in the applicable law in case if there is no choice of law. As the EU regulation focusing on the first common usual place of the residence after marriage, which can be amended in a special case to the last place of common usual residence, but both are question of proving. And as the common citizenship have significance only if the parties never live together seriously in the usual place, and finally, if there is no common citizenship that then it reopens to the direction of the residence place with the closest connection. It means that if we would like to gain consequences, which is the best way to regulate matrimonial relations in respect of stabilizing the applicable law, then in my opinion, we have to focus on the liberty of choice of law, because the present regulatory environment doesn't give this wide liberty to the parties independently on the fact that the said country is participating in the EU regulation or not. But this is only my opinion, one of the opinions of all of us. So it was very interesting to hear all of your opinions. And for me, again, this conversation was very, very interesting, and besides very valuable. I got a huge amount of useful information about international matrimonial relations, and I'm sure that without any doubt, the material we created now will be a great part of our conference, and good for either interested professionals or the researchers as well. So again, dear colleagues, I would like to say thank you for participating in this conversation, and wish you a very, very good day in the followings. So thank you again.
Yeah, thank you very much.
Thanks for the invitation.
Thank you.